Hello everybody. So in this presentation we're going to talk about students' rights and due process. And while this presentation is going to concentrate on really students who are suspended from school for a short time or a long-term suspension, the rights that we're talking about and the processes that we're going to see, I would encourage you to use throughout all of your disciplinary actions that you take with students. And you will see what I'm talking about as we go through here. So the first thing then is how the courts are going to look at school attendance. And so we see here that school attendance has become such an integral part of a citizen's life and upbringing. The courts have elevated school attendance to a constitutional interest, and students cannot be deprived of a constitutional interest without due process. In other words, we in America feel that it is so vital or important that a student attend school, that school attendance and the obtaining of knowledge through school attendance and becoming a better citizen has become a right under the Constitution. And as we're going to see, we're going to talk a little bit about liberty and property interest, and that's where it comes into play. The key here is that once a state extends the benefits of education to all persons, and all states have done this, education acquires the substantive constitutional status of a property interest and requires due process to remove that interest. The liberty interest also applies when a state extends the benefit of education to all persons. So that's what we're going to talk about, is the property interest and liberty interest at first here, and then we're going to move into the process to take away these rights. So among other things, the two constitutional issues at which we're looking is the 14th Amendment. And I have quoted the amendments here for you. No state shall make or enforce any law which shall abridge the privileges of immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process. Well, then we can look at the Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. As we have stated in the past, the 14th Amendment was used to incorporate the Bill of Rights down to the state level, and so all parts of the Bill of Rights have now been incorporated into the state level. And so that's why you'll see cases when they go to the court, they say we're suing or we want a judgment based on the 14th Amendment and the 5th Amendment, and then maybe another amendment. When we're looking at the amendments, like the rights of the accused, and we typically see those in Amendment 5 and 6 and 8. When we look at those amendments, that's where we're talking here. The saying that no person shall be deprived of life, liberty, or property without due process. What we're really looking at is what liberty and property are. So let's move into that a little bit, okay? So due process, we have two types of due process here. Substantive due process, which initially might feel a little bit more intangible, and then procedural due process. And most of what we're going to look at deals with procedural due process, and we're going to end with some nice summaries of the procedural due process steps that you can take as an administrator to ensure that you are legally taking away this right from a student. So keep in mind what we have said. The courts have ruled that obtaining an education is a liberty or property interest. And in order to take that away, you have to follow due process. That's what the Constitution says. So substantive due process then. Substantive rights are those that are implied by the words of liberty and property. Substantive due process relies on the rules and regulations written by educators to regulate or control student behavior. In other words, your handbook, your policies, etc. If you are going to deny a student a free and appropriate public education, which we will use that term in a minute, that is considered a right, and so you have to have in place the policies that state what could happen if certain rules are broken. And that, of course, comes in your handbooks, in your policies, and so forth. And all that makes up substantive due process. So if you were to have a case where you did not have a policy regarding an instance and suddenly realized, oh gosh, this needs to be a policy because this was a bad thing that this student did, therefore I'm going to punish this student and we're going to create a policy. Without that policy in place, you have violated that student's substantive due process. So hopefully you get a better idea of what we mean by substantive due process. Procedural due process, a little bit easier to grasp. This is the actual procedures that you have to go through to take away the person's right. And the courts have ruled that in general, to do this, the accused has to have proper notice, an opportunity to be heard, and given a hearing that is conducted fairly. And in the end of this, we're going to look at lots of steps that go into conducting a hearing fairly. But let us continue. So, substantive due process. So here is where we're going to define a little bit more of how liberty and property, and again, these are words taken directly from the 14th Amendment and the 5th Amendment. We're going to define how these have become known as the right for students to go to public schools. In 1923, the court in the case of Mayer versus Nebraska stated the word liberty has a substantive aspect which invests each person with a protected interest in acquisition and conveyance of knowledge. So we see it going toward education in the 20s. There was really nothing more significant that come of this until the 60s and 70s. And the two cases that we're going to continuously refer back to throughout this presentation are Dixon versus the Alabama School Board of Education, 1961, and then Goss versus Lopez, 1975. In the Dixon case, what the court did is, you can see this is 38 years, almost 40 years later, elevated Meyer to the point that education was so important that to take it away required procedural due process. And in essence, education became a property interest. And then Goss, 15 years later or so, securely stated that education falls in the scope of liberty and property for common education. So what we mean then when we talk about a liberty interest is based upon these cases here. In Meyer, it said that education was important enough. The term liberty implies that a person has an interest in the acquisition and conveyance of knowledge. In Dixon, it said it's so important, the court said that education is so important that this liberty interest has to be taken away through due process. And then Goss finally says that not only is there a liberty interest, there's also a property interest, and that in order to take away either interest, either aspect of education, there has to be due process. So property interest, think of property interest in the sense of owning a contract. So if the state says that there is a free public education for all citizens, then that's a property interest. That's kind of like a contract that you have with the state, that your state is going to provide that free and appropriate public education. And therefore, as an agent of the state, the school district, but more specifically the principal, cannot take that away without due process. And here again, when we say take it away, we're specifically talking about suspensions. suspensions or expulsion from school. That's what we mean when we say taking it away. If I'm going to send a student home for 5 days, 10 days, or 20 days, I'm taking away that free public education, that liberty interest, and that property interest. And in order to do so, I have to follow due process. That's what this whole presentation is about. So there is one small section in the text that talks about this term conscience shocking. And the courts have ruled that substantive due process is necessary, but only if government actions is so invasive and arbitrary as to be conscience shocking. So in other words, again, keep in mind what I said, that you need policies in place. So you're not always going to have policies in place to cover every aspect of an infraction. And what the courts have ruled with this conscience shocking idea is that the government action has to be so bad that it's a shock to our normal conscience. And in that place, if there is no policy, then substantive due process has been violated. But look at the next bullet here. And this is what the court has ruled is not conscience shocking. So it would be interesting to see what is. But the Alexander and Alexander tell us what is not. So there were two instances in the book. The first one was when a school suspended a student with a mental disability, took the student home, and left the student at home knowing there were firearms in the house. The student committed suicide. And this was not considered a violation of the substantive due process, even though it wasn't in policy that this is what would happen. Also, giving students Fs, giving Fs to a student in a band for ignoring the rules. There was a story in there about students going on a band trip, and they flagrantly ignored the rules, got up in the middle of a performance, and apparently did some type of solo performance. And as a result, the teacher gave the students F, and the F ultimately caused the student not to graduate with honors. And the courts ruled that that, in and of itself, was not conscience shocking. So, in other words, what the court is doing is giving a lot of latitude to the schools here on their policies. The key thing, and you're going to hear me stress this throughout, is you have to have policies in your handbook for your students, in your handbooks for your faculty and staff, and also in your board policies. And once you have policies, what conscience shocking is stating here is that those policies don't have to be so extensive as to enumerate everything that could possibly happen. It's just that if you have them in there and you follow them, you're most likely going to be okay. So let's take a little bit more look here then at what we said property and liberty interest are. So property interest, again, created when a state statute entitles all citizens to a certain benefit. Here we're talking about FAPE, or a free and appropriate education, a free and appropriate public education. This is a property interest of all citizens of the state. Liberty interest, we talked a little bit earlier about liberty interest being the fact that you have a right to acquire knowledge, and this has been elevated through Dixon and Goss. But also liberty interest entails more than just that. It includes a person's good name, their reputation, their honor, and integrity. So with that definition, then, you can see how suspending a student for whatever the infraction might give that student a bad name. And so as a result of that, you are taking away that liberty interest that that student has of their good name. And so in order to do that, again, you have to go through these steps. So for government to take away these interests requires due process. So then what process is due? And we're going to talk about due process, but here it's just kind of a play on words. What process is due? So when it comes, and we're going to go through a few things here talking about punishments. In general, when it comes to penalty, the penalty for an infraction a student commits has to fit the nature of the offense. In other words, if you have a student who you said, uh, we used to have policies about tardies. We used to concern ourselves about tardies, probably too extensively, but that's neither here nor there. But the policy continued on so that ultimately a student could be suspended a day out of school. If we had said, and the suspension occurs after multiple infractions against the tardy rule. If we had said initially, the first tardy a student has, the student is suspended a day, that punishment does not fit that offense, that crime. So that's what we're saying here under penalties, that the penalty has to fit the crime. So building up to a day out of school for multiple tardies is more appropriate for that. So also under penalties, penalties must be legal, a part of your policy. Quite often, it's not uncommon to see penalties fit in with and reference state statutes, especially in board policy, not necessarily in handbooks, but your handbooks are going to be supported by your board policies, and typically when I look at board policies, quite often that's where you're going to see board policies reference state statute. Okay. Corporal punishment is legal in the United States, Ingram versus Wright, 1971. So corporal punishment is allowed. It is also allowed in Oklahoma. It's not allowed in every state, but those states that do allow corporal punishment, it is legal. It is allowed in Oklahoma. It's probably going out a little bit more as opposed to getting more popular. The courts ruled in Ingram versus Wright in stating that corporal punishment was legal, that this did not violate the Eighth Amendment against cruel and unusual punishment. An interesting study that I did when I was in graduate school, by the way, we looked at administrators around the state and we asked administrators about corporal punishment. And we asked them their years of experience as a principal, the size of school in which they were, the county, I think we got the county level, which county they were located in. Anyway, nonetheless, we were able, whether they were male or female, we were able to determine the typical profile of an administrator who delivered corporal punishment. And so I don't know if it's not surprising now because I've talked about this since we did the study, but the typical profile of an administrator who administers corporal punishment in Oklahoma 10 years ago was they were in a rural area. Typically, they were practically all male, typically very young, and had less than 5 to 10 years experience as an administrator. What we saw was as experience grew, administrators tended to do more counseling with students as opposed to using corporal punishment. And as an administrator myself in a district that allowed corporal punishment, I'll say that profile fit me to a T. We definitely felt fine to administer corporal punishment, but as I became more accustomed to the role of administrator and as I got to know my students a lot more, I moved into that direction of more of a counseling role than one who administered corporal punishments. Typically, though, the more severe the punishment, the more stringent the responsibility is on due process. And we're going to hear that theme throughout. If a student is suspended for a day, they're probably going to be a lot more flexibility in due process as opposed to a student being suspended for the rest of the year. So just a little thing on penalties there once you do decide on a penalty. Immediate temporary suspension. If a student does something and you're going to suspend them immediately, the courts have ruled this is legal. If you can show the students whose presence imposes a continuing danger to property or constitute an ongoing threat of disrupting the academic process. that student may be immediately removed from school. And typically what we're talking about here is probably fighting. When students are fighting, you can bring them into your office and suspend them at that moment. There are going to be other steps involved, but the courts have ruled that that is illegal to suspend them at that moment. A few more things here with what process is due, dealing with penalties. Alternative placement. And alternative placement here, we're talking, could be in-school suspension. That's mainly what we're looking at here. There is some at-home services. You don't see those nearly as much, but there are homebound students. If you have an alternative placement, in other words, if you're going to take a student out of the mainstream classroom and put them in school suspension, we will learn later on that due process is not necessary in all these instances. And the logic behind that is because you're not depriving the student of that liberty and that property interest in providing a free and appropriate public education. The key is that in an alternative placement environment, you are still providing the student an education. The Alexander and Alexander have a little section on zero tolerance policies, and those became very popular for a while in the early 2000s. Part of that was due to No Child Left Behind, which instituted a zero tolerance policy for firearms. Zero tolerance policies do not change nor reduce the requirements for due process. Even if you have a zero tolerance policy, you still have to carry out the due process. You know, there's some interesting stuff in there. I'm not a fan personally of zero tolerance policies. I think that they take the humanity away from being an administrator and addressing individual situations. One of the key concerns with the courts was about being uniform in penalties when it comes to zero tolerance policies. I certainly believe that you have to be uniform in your judgments and your rulings as an administrator when it comes to discipline. But again, zero tolerance policies, I think, just take away too much of that. Litigation, when we're talking about zero tolerance policies going into the courts, typically fall into 5 categories. The first one is adequacy of proof or violation. You know, here I think that what Alexander and Alexander are talking about is when we see zero tolerance policies about weapons, and you find an elementary student who has a plastic knife that his or her mother put in their lunch pail to cut a banana or something. You know, is that a weapon? You know, so adequacy of proof or violation. Whether procedural due process was afforded is another area where we see zero tolerance policies fall into court. Arbitrariness of application. It goes back to that idea you must be uniform in penalties. If you suspend that student for bringing that plastic knife to school in his lunch pail, then you also have to suspend that straight A honor student who accidentally did the same thing. Okay. Vagueness of regulation. One of the things that we're going to really hit on as we go through the due process piece is vagueness of regulations. Your policies cannot be vague. They have to be pretty specific. Now again, they don't have to be so specific to describe the conscience shocking aspect, but in general they cannot be vague. So when they say disruption of the school process, you know, that's pretty vague. They have to be more specific than that. And then technicalities of a hearing's fairness, and that falls under due process as well. So these are the reasons that we typically see zero tolerance policies fall into the court. And again, I want to stress this here. Make sure that whatever you're doing, that your policy reflects state statutes in all areas. And again, this can be just your board policies, so that when a parent looks at the student's handbook and has a discipline code and they refer back to board policies, then they can see where that goes back to the state statutes. So anyway, just a little background information there about penalties that you're going to mete out as an administrator. We talked a little bit about substantive due process. Now we're going to spend the rest of our time talking about procedural due process. And with procedural due process, here we are concerned with the procedures involved in actually taking away the student's rights. We're talking about liberty and property interests that students have, whether the liberty interest is that faith, the free and appropriate public education, or it's the good name or honor of the student, or that property interest. I guess faith really is a property interest, the free and appropriate public education. Whichever one we're dealing with, and quite often it's both, when we suspend a student, we have to go through these steps. Okay, so the first big thing here is impartiality. In other words, judicial treatment. And here we're talking usually about the principal. In the school, this is the treatment of the principal to the student. The principal must be impartial in his or her treatment of each individual case. So there's some room where you can talk about a student's history, obviously, but in general, you can't say that because this student was a straight A student and this student has already been suspended 3 times, even though they did the same thing, I'm going to suspend the first straight A student 1 day, and I'm going to suspend this other guy 2 days. That's not impartiality, okay? Assuming that this is something completely different from the other student and all that the other student had done. Fairness. By fairness here, we mean a right to be heard. The student has a right to be heard. But more than that, what does fairness mean? What do we mean by hearing? Does the student have a right to confront witnesses? Is there a cross-examination of those witnesses by a student or by a lawyer? Does the student have a right to have a lawyer? If the student's getting ready to be suspended for a semester, is there a lawyer? Can a lawyer get involved? Does the student have a right to remain silent against self-incrimination? You know, all these things are parts of the Bill of Rights that we see under rights of the accused. So do these fall to students? And to what degree do they fall to students? And all these fall under the larger category of fairness. So impartiality, we have to have an unbiased administrator administering judgment, and then fairness. And what does fairness mean? So that's what we're going to look at as we finish here. So again, to go back, the 2 main cases dealing with suspension of students and taking away their rights are Dixon, 1961, where the court ruled education is a liberty interest and due process must always be followed to take away this right. In Dixon, they specifically stated these 4 things. There must be an impartial tribunal. Here we're talking about a principal. It could elevate to the level of board, and one of the things that you have to have in policy is a place to appeal the decision. Typically, once it gets to the board is the final decision, but it's not uncommon to see a disciplinary hearing or a discipline scenario go to where the principal goes through the process, administers judgment, and disciplines the student. The student and his or her parents appeal. They go before a hearing committee, and that committee then will listen to all the evidence from both sides and make a judgment. And from that committee, the parents typically can appeal to the school board, and the process is repeated. Once the school board is done, then that is it. There's no going beyond that. When they go beyond that, we start getting into those other areas we talked about, such as vagueness of rules, arbitrariness of decision making, things like that. Okay, so that's what we mean by an impartial tribunal, whether it's the administrator, the appellate group, or the school board. Notice of hearing and charges. And under notice of hearing and charges, this can be instantaneous. And it kind of goes obviously with Number 3, if you have students who are fighting, you don't have to schedule a hearing 2 days down the road. You can pull your students in and discuss it and say, this is our hearing. We're doing this right now. You each have a chance to say your sides of this story. And so this is what you're being charged with, fighting. According to the handbook, fighting is a suspendable offense, and you were caught fighting. So tell me why you should not be suspended. And so you're rolling all those together. So these are not things that have to take place over time. These can almost be instantaneous. So a hearing to refute charges, and then finally a decision on the evidence, open and accessible to the student. And typically what happens when students are suspended is there are letters. We used to send letters by certified mail home to parents stating explicitly the rule that was broken and why the student was suspended and for how long the student was suspended. In Goss, 14 years later, the court ruled all suspensions from school required the steps detailed in Dixon. Before Goss, you typically only saw these things in long-term suspensions. But as a result of Goss, even just 1 day out of school, all these procedural due processes had to be in place. So what are these processes? So we're going to go through these processes a little bit at a time here. Number 1, notice. Again, you have to notify the student. The notice should contain a statement of the specific charge and the grounds which, if proven, could lead to appropriate disciplinary action. Problems here that schools find themselves in are when their policies are vague. Your policies cannot be vague. Again, I said that earlier. I'm reiterating it now. Your policies cannot be vague. The notice can be a written notice, or it can be an oral notice. You can call and communicate with the student's parents over the phone. It must be noted the notice was clearly communicated to the student, and typically on the forms when we suspended students, we had areas where we would mark the date and time of all this occurred. Miranda warning. So, do students need to be notified of their Miranda rights? Well, in most cases, the answer is no. Students are not entitled to Miranda warning if the investigation is conducted by a school official. And in this case, a SRO who is working for the school would be considered a school official and not need to Mirandize the student. We talked about SROs earlier. Where it becomes necessary to Mirandize the student is when a police officer, and I see there's a spelling there, when a police officer acting as an agent of the municipality starts to investigate. At that point, he or she has to Mirandize the student and let them know of their rights. Okay, but until that point, students are not entitled to a Miranda warning. What they are entitled to is an opportunity to be heard. Students have to be given an opportunity to state their case. This can be oral or written, and depending on the severity of the case, I would suggest that you get both. You can typically have the students write down their stories of what happened, and then once they write the stories down, when I used to investigate students who were fighting or whatever reason, I would have them write down their version, and once they did their version, then I would take it and glance over it real quick, and then we would start kind of an oral investigation at that point. Access to evidence. Students must know the evidence against them. And Dixon states that students should be given the names and witnesses against him or her, the actual quote said him, and an oral or written report of the facts to which each witness testifies. So a student does have a right to know who is testifying against him and stating evidence that they believe requires the student to be suspended from school. Again, typically when I suspended students, it was usually for fighting. It seemed to be the most common reason, and at that point, it's obvious the person who's testifying against you is the guy or the girl you were fighting. So, but students do have a right to know all the evidence against them and to confront their witnesses, or not confront their witnesses, but know who the witnesses were. Confronting or cross-examination witnesses is a different story. While it's a fundamental right as citizens of the United States, courts have been more lenient on students and not allowing them to cross-examine witnesses. And so I would all the time tell students in situations where they were fighting that they could not talk to each other. If I got them in the room, if I felt comfortable getting them in the room together to talk about what happened, I would not let them talk to each other. They were only talking to me. So there's no cross-examination of witnesses allowed to students. And part of the logic behind this with the courts is that ultimately, if it got to the level of the board where the board had to make a ruling, the board has no subpoena power. So the board is allowed to take testimony from students or other stakeholders, but yet the board cannot compel those stakeholders to come and testify at a board hearing. Therefore, it is not guaranteed that a student would have the witness to cross-examine. And so as a result of that, courts have generally said that students don't have that right even at the inception of the infraction and the hearing in the principal's office. Hearsay is generally admissible in formal school disciplinary hearings. Hearsay means that instead of the students having a witness there, the student says, "My friend told me blah, blah, blah." Okay, that's hearsay. Generally, that's admissible. So let the students talk and say all that. And typically, from experience, what you get from that kind of stuff is a paper trail that you can go track it down and find out where whatever it is that caused the scuffle, the fight, whatever, you can usually trace it down to its inception by listening to the hearsay and then going and talking to those students and find out where it came from. Legal counsel, not required for a suspension of 10 days or less. It may be used along with cross-examination for suspensions greater than 10 days. This is not a basic right of students, though, and I've had to suspend students for multiple weeks, and in none of those cases did I ever have students come back and say that they wanted legal counsel present or that they wanted to cross-examine witnesses. Typically, there were not necessarily witnesses to cross-examine. I was the one who had the evidence, and so they would ask me questions, so maybe they did in that sense. But legal counsel is never required. If a student wanted to have a lawyer, that would be something to work out with your superintendent. Typically, I would say that it's not necessary under 10 days. So if it's 10 days or less, I typically discourage it. But again, work that out with your superintendent, and he or she will work that out with their lawyers and go from there. I've never had to deal with legal counsel issues with student suspensions. And then the last one on this slide is an appropriate tribunal. Again, all this is about what's procedural due process. Appropriate tribunal, here what we mean is he who hears the evidence has to administer the punishment. So we cannot then have the principal listening to all the evidence and taking notes and then passing it up to the board for the board to decide what to do. That principal who hears the evidence has to be the one to make the judgment on the evidence and then decide the punishment as a result. The last little bit here about some questions you might have about procedural due process. Not uncommon to hear students say, I take the Fifth Amendment, and I'm not going to answer that question. The Fifth Amendment, as we know, guarantees the rights of the accused against self-incrimination. Unfortunately for students, this does not apply in education settings. Okay, and so students cannot refuse to make statements based on taking the Fifth. Character witnesses. Typically, if students want to bring character witnesses to a school board hearing, if an action gets that far, that's allowable. Again, I would err on the side of caution as an administrator. If a student wanted to bring a character witness, then by all means let the student bring a character witness. If anything, it's going to give you even a little bit more insight into the student and the background and so forth. It doesn't change the immediate scenario necessarily, but it gives you some more background information. Double jeopardy. Double jeopardy goes way back in legal history, 800 years. Double jeopardy, being tried for the same crime twice. The courts have ruled that it does not apply when you're dealing with federal charges versus state charges. That's why you can, if you commit murder, murder is a federal crime and a state crime, you can be tried for the same crime in different courts, okay? And that is not double jeopardy. The same thing applies in schools. Double jeopardy is not applicable to schools. If a student is convicted of a crime outside of the school by either the municipality or the state or district court, then the school, if policy is in place that would address something of this nature, again, substantive due process, if the policy is in place, then the school can turn around and discipline the student for that same infraction. And there are a couple examples in your book. They're pretty severe examples, but there are a couple in there. And that is not considered double jeopardy. Okay. And finally, again, the last one here, we talked about this, in-school suspensions. If a student is serving an in-school suspension and being provided an education, then due process does not apply. These things don't apply. Again, due process applies when you are taking away that liberty, interest of the student's good name, the right to an education, and that property interest, that guarantee that an education is a state-supported right. With that said, I would advise you to follow due process in everything you do, because you're just covering yourself so that nothing can come back on you. And so whatever the infraction is, follow the same steps as if it were something that did require due process. It's all about documentation, 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 documentation. This is what the student said. This is what the student wrote. This is when I talked to the student. This is when I contacted the parent. It's all about documentation, okay? Because keep in mind, if you are ever subpoenaed to court, if it got to a point where you had to actually go to court outside the school system, then one of the things that is going to come out in an evidentiary hearing are all your records. And you want your records to be clear, and you want a history of how your records are clear so you can show that to any judge or jury, okay? So I'm going to give you a couple of steps here. So some proper procedures to follow. There's a little bit of flexibility here, but these are 5 basic things. And then we're going to look at the guidelines to fairness. And again, we've talked mainly about fairness here. Again, number 1, a notice should be given with the specific charges. That's the letter sent home to parents. That's you telling the student why they're in your office. Number 2, a hearing should be conducted, affording the administrator or board with the opportunity to hear both sides in considerable detail. That's you talking with the student. The student should be given the names of the witnesses against him or her and an oral written report of the facts. That typically doesn't come up, but if it did, the student would have to know the names of the witnesses. They do not have a right to cross-examine, but they do have a right to know who the witnesses are. The student should be given an opportunity to present his or her own defense and produce oral and written affidavits in his or her behalf. Again, this is going to happen as you investigate and discuss what happened with the student in your office. And then finally, the hearing must be before a board responsible to hear and make decisions in the case. And again, that goes back to that he who hears the case has to make the decision. And that's going to be typically you as an administrator. And a lot of this really goes to you who are APs, because so we know that a lot of APs deal with disciplinary issues. So if you're dealing with a disciplinary infraction and you hear the case, you have to make the decision by law and not push it up to the principal and say, here's the evidence in this case, you decide. You're the one who's hearing the evidence and making the decision. And then you can get support from your principal, but it's not the principal who's making the decision. So just keep that distinction clear, okay? So just a little bit to expand on those 5 things here. We have just 3 more slides here. Just to expand on those and incorporate fairness, okay? If the punishment is severe enough to deprive a student of schooling, even for just a day, the student has a right to be heard. And again, I would encourage you to use the same due process rights in any disciplinary situation. Okay, the student has a right to be heard. Number 2, notice should be given conveying the specific grounds with which the student is being charged, citing rules or regulations which have been broken. Your rules cannot be vague. So if the student really brings up a clear question of vagueness, you have to take that into deep consideration, okay, because your rules cannot be vague. Number 3, notice should be delivered to the student in writing in sufficient time to ensure ample opportunity to prepare a defense. Typically, what we did when we suspended students is I would copy the paper that I mailed home to the parents, and in this paper it gave all the stuff that it's asking for, the rule that was broken, the punishment, the notice, and all that. And then at the end of the paper, we would always put on there a date and time by which we had to hear from the parents if they wanted to question the judgment or the penalty. And so notice is delivered to the student in writing in sufficient time to ensure ample opportunity to prepare a defense. Usually what we would tell the parents, I can't remember, but it was something like, within the next 48 hours, if you want to contest this, then you can contest it and come up and we'll create a next level of hearing. It didn't mean that you and the parents couldn't talk and discuss things. But once you made your decision and you sent that home and said the student is suspended, the parents had to have time to make their case. And if they said, yes, we're going to make our case, and they came up and it was reversed, then all the negative things that were attached to the student being suspended for 2 days until that hearing was established were erased. Okay, that's just how it works. Number 4, the burden of proof is on the school, not the student. Number 5, the student should be given an opportunity to testify and present evidence and witnesses. Number 6, the tribunal, again, most likely the principal, should make a decision with only the information presented in the hearing. So here you have to kind of play Judge Judy and really get in there because you're basing your decision on the evidence you have in front of you. And if you ever go to court and you have to deliver your records, then your judgment, your decision has to be clearly made from just the records that you have in front of you. Okay, so just keep that in mind. Number 7, all evidence should be made available to the accused unless for some reason it could harm them, then you don't have to. But otherwise, all evidence against the student needs to be made available to the student. Typically where I saw this come into play was when students were caught on video camera doing something and the parents wanted a copy of the videotape. And so in these cases, what the court is saying here is all evidence must be made available. So I would make a copy of the video, the segment showing the student, and say this is the evidence that I used to make my decision. And you have to make that available to the parent. Cross-examination is not required, but may be for really serious offenses. Again, those long-term suspensions where it's really in question. And to be honest, I can't think of anything offhand that would require cross-examination, because usually the long-term suspensions were straightforward, dealing with drugs and alcohol or weapons. And those tend to be straightforward. But if they wanted to cross-examine, chances are you probably should allow that in those long-term suspensions. Again, always contact your superintendent, who will contact the school's legal counsel for specific questions. Legal counsel is not essential, however, just like cross-examinations, if the case is serious enough, then it may warrant legal counsel. The administrator who hears the case must deliver the judgment. Two more things here. The students have no right to remain silent. Whether they believe that or not is not important. The courts have not given students the right to remain silent. And then finally, hearsay is admissible. So, again, just to reiterate here, the courts have ruled that attending public school is a property interest that all citizens of the state have, and that acquiring knowledge along with a person's good name and reputation is a liberty interest, and that according to the 14th and 15th Amendment, in order to deprive a citizen of these rights, life, liberty, and property, that due process must be made available to the student. And so what we have looked at are two types of due process. Substantive due process, what do rules and regulations say, how are they interpreted, and then procedural due process, what is the actual procedure done in order to take away the student's rights. And here again, we're saying when we're taking away these rights, we're talking about suspension or expulsion of a student from school, taking away that liberty interest and that property interest that a student has in their education. So hopefully that gives you kind of a background. Of course, this starts to fit in with all that we've been discussing on students' rights as far as speech and search and seizure and the press and all that kind of stuff. Okay? So hopefully that makes a little bit more sense to you on guidelines that you need in order to take away students' rights.